I think we were dealing with admissions.
Yes, sir.
Yeah, admissions commencing from section 17 till section 23 तक है. Last time कहाँ पे किए हमने? Any idea?
Sir, we
Uh,
can start by 21.
21. Okay. So all of you know that here admissions are the evidence by admission can be used both in civil proceeding and criminal proceeding. So civil and criminal proceeding, I'll give you some illustrations. In the CPC, there's a specific provision itself with the under order 12 CPC admission say judgment can be passed on admission. Then order 10 rule 1 commands that here the learned judge may ask parties on the date of the first hearing whether he's admitting the claim or not admitting the claim. पढ़े आपने CPC के अंदर, isn't it? Order 10 rule 1 के अंदर. Then you mentioned that under the provisions of a written statement, when you written statement must be specifically denied, bare denials amounts to admission. पढ़ चुके ना order 8 rule 5 के अंदर पढ़ चुके हैं. Then interrogatories के अंदर under order 11 rule 1 CPC, the question answers which have been asked. So I'll take it from here. Take it from order 8. Order 8 CPC के अंदर you know that here 8 1 2 3 tells you that the denials must be specific, not evasive one. Evasive denial tantamount to admission of the plaintiff case. There will be decree against you. Then you take order 10 rule 1 खोल लीजिए आप. Under order 10 rule 1, the court on the first date of the hearing, that is when pleadings are completed, ask the parties whether they are admitting the claim, which portion, and disputing the claim. Order 8, order 10 rule 1. Order 10 rule 1 CPC, which I'm sure you will not forget this because you just had exam last time. Then order 12 is a very specific. Order 12 se pehle there are interrogatories under 11. The interrogatories which are used asked by the parties where you admit, they are also admissions. They can be used as evidence. Then order 12 makes a specific provision. So under order 12 rule 1 2 the parties can give notice. Then order 12 rule 6 check kare aap, the court can pass a decree on admission. Isn't it? So these are the various illustrations in the code of civil procedure relating to admission. Of course, the admission itself is not defined. The definition is section 17 and 17, 18 of the Evidence Act defined. As so far as CRPC is concerned, CRPC, there is no procedural law as such with regard to admission. But you know that by virtue of the provisions of saving clause, you can use the provisions of Indian Evidence Act and also the provisions of Code of Civil Procedure wherever the act is silent. The saving clause of every act tells you that. Now, for example, what are the admissions in criminal case? Now, at the time when the trial takes place, a session trial, a warrant trial, starting from section 225 onwards. Then a trial before a magistrate in warrant cases, trial in summon cases. So at the time, the admission such as what the accused person had stated in the affidavit at the time of the securing bail, that can be an admission with regard to whatever he has stated. समझे ना? The bail application में जो use किया है, he can be confronted in the cross examination. देखिए, in your statement before the court you are saying something different, and in the bail application you made the application. So keep the bail application ready with you, all papers and proceeding certified copies. Whatever admissions people have made it, bail application, remand application, statement under 161, 162 के अंदर पुलिस ने रिकॉर्ड किया गया है. Of course, they are not evidence, you can contradict them because they can be used by you under section 33 of the Evidence Act in the same proceeding. So these are all admission. You can ask him that why your stand is different from the one other, the stand which you have taken earlier in the before the court of session. You filed writ petition for quashing proceeding before the Honorable High Court under 482 or 226. वहां पे अलग statement है. So these are all admissions. Please, they are not specifically mentioned in the CRPC, but they are all tantamount to admission. admission of a certain thing, certain facts. So ये सब चीजें ध्यान रखिए आप. The CRPC में भी admission लगेगा and can be used as evidence and the Code of Civil Procedure. So 17, 18 I explained to you, and also 19 admission by person must be proved as against the party against him. So the person who makes the admission, confessing that, admitting that he owes certain money to somebody. Not a statement that I am a great man. The man may say that my grandfather was a generous man, he used to donate money to everybody. That statement is not admission. If you make a statement that here, my grandfather wrote in a diary that he has taken a loan from Mr. XYZ, that is an admission. समझे ना आप? The statement must be confessing the liability, admitting the liability. Yeah, next. Now next आ जाइए, 20 आ गए. Refer to the party in a suit में 20 cover कर लिया हमने. Yes, 20 also we gave the illustration. Now 21 पे आ जाइए. Proof of admission against person making them and by or on their behalf. So the admissions which were made by a party or on their behalf, by the representatives, by their power of attorney holder, by their successor, by their advocate, expressly or impliedly. Admissions are relevant and may be proved as against the person who making them or is representative in interest. Now this expression representative in interest mean a person claiming through him. So this expression you will find in many places in the Specific Relief Act, section 15. Who can file a suit? Parties to a contract and representative in interest. And 19 के अंदर you will find in the Specific Relief Act, suit can be filed against whom? By the parties and also against the representative in interest. So you may have sold the property. Suppose I enter into a contract with you, agreement of sale. मैंने honor नहीं किया, but I sold my property to Mr. XYZ. So that is, he is your representative in interest. Or the person who entered the agreement dies, his children, or the transferees. So they are the persons represented in interest, but they cannot be proved or by on behalf of a person who makes them or by representative interest, except in the following cases. Now, what are the exceptions? It can be an admission may be proved by on behalf of a person making it when it is of such a nature that the person making it were dead. So this is section 32 attracted. After making statement, after lodging FIR to the police station, the person dies. Because FIR is not a substantive piece of evidence. The maker of the FIR is required to be brought to the court and give evidence. If he dies, his statements become admission. It would be relevant as it between third person under section 32. So in the FIR, if he says that I have seen the accused assaulting Mr. X, the victim, and he dies, that statements can be used against him because this is relating to the circumstances of the death. So these are admission, they may not be confession. That is one. Under 32, where dying declaration chapter take place, 32 ke andar there are 8 subsections. I will take it through when I'm dealing with it here. So that's an admission. A person makes a complaint to the police officer, or a person's statement are recorded under 161. Because police is giving you notice under section 41A, following Arnesh Kumar's judgment. Notice देने के बाद you visit the police station, your statements are recorded. Technically speaking, your statements are not evidence. But after recording of the statement under 161, if a person, the witness dies, they can be used under 32. That becomes admissions. They can be used in certain circumstances. Please note that here. One illustration. Number two, An admission may be proved by or on behalf of a person making it when it consists of statement of the existence of state of mind or body. So यहाँ पे section 14 is invoked here. What was what was the state of mind of the victim or the accused at the relevant time when poison was administered? Huh? What did he say? Mind, body, relevant, or an issue made at about the time when such state of mind or body existed and accompanied by conduct rendering it falsehood improbable. So the gentleman who died, he made a statement on the phone. He informed you, look here, my friend, I came here to have dinner with my opponent. He invited me. I was a hale and heart after you doing my yoga or my gym. Suddenly, after drinking the juice which he gave me, I'm feeling sleepy and my body is becoming blue and red. वो फोन में बताया आपको. You be a good friend, or he told his wife. Then he collapsed unconscious. So that was the state of mind and body of the man who indicated to you, or who indicated to his best friend or a family member. So it is highly improbable a person who is about to die would make a wrong statement, a false statement. The court shall presume that statement to be correct, or draw a presumption that here it is likely that he has made it correct. Nobody on the verge of a death will make a wrong statement. So he expresses कि I am feeling suffocated, I am feeling very bad, nausea, and मुझे मरने की हालत हो गई. And I came hale and hearty here. And in case I die, you will have to lodge a FIR against him, this gentleman only. समझना? ये state of mind है इसका. You may not have recorded it. You are a person who heard it, who saw it. So state of mind के लिए, these are the admissions which he made to you. They may not be confession. And accompanied by a conduct considering a falsity. Court will say that here. So an inference will be drawn by the court of law. May presume, shall presume. Under 114 के अंदर. And under 32 also, the man would not make a wrong statement. Then, number 3, an admission made by may be proved by on behalf of a person making it, if it relevant or otherwise as an admission. So if it is relevant or otherwise admission as defined under section 17, mean a statement, oral or documentary containing electronic form, suggesting an inference as to any fact in issue, which is made by him. So a man make a statement that I had handed over my checkbook and my peon has misused my signature and drawn money. Then the man is no more. And it is possible he has fabricated many entries and got them in cash. So these are admissions. Now let us see the illustration to understand this section 21. The question between A and B, the question between A and B, whether a certain deed is or is not forged. A affirms that it is genuine, B it is forged. So for a declaration that the instrument is sham, colorable and bogus, a suit is filed under the Specific Relief Act, that this honorable court be pleased to declare the document illegal, colorable, set aside the document. Or some mischief and mistake has happened deliberately, my name is not mentioned in the instrument, that this honorable court be pleased to rectify the instrument under section 22 of the Specific Relief Act. You learned all this. So A is asserting, this is my signature has been forged. B says, no, it is the correct signature. Now let us see whether who should be believed. A may prove a statement by B that the deed is genuine and may prove a statement by A that the deed is forged. A may prove a statement by B that the deed is genuine, and B may prove a statement by A that the deed is forged. So there is a letter written by A stating that here I have taken search of your title deed. I am satisfied. When I am purchasing your property, we have agreement. There is an agreement of sale between you and me under section 54 of the TP Act. The other party takes up the plea. It's a fraudulent document, fraudulent transaction under section 53. And I take up the plea. No, it is a genuine one, a statement. You wrote me a letter. I take an inspection of the genuine deeds. I concede this problem. That's an admission as against me. Yeah. A may prove this statement by B. So B would say that I have taken inspection searches of the title deeds. I am quite happy with the document. I am satisfied and I will pay you earnest money. A sum of rupees 1 lakh and remaining amount. That is an admission contending that here the document is he has taken inspection from his solicitors. So he can't take a somersault and back out. My statement is wrong. He wrote a letter because you are consulting your solicitor and take an opinion. You may say that here I have advertised in the newspaper inviting objection. If anybody having objection with regard to the property which is sought to be claimed, which purchased, and nobody, there is no objection. So I'm convinced. So that particular statement is an admission. If tomorrow, if a suit is filed for specific performance or a breach of contract under section 10, 12, 13, 14 on the ground that he doesn't have title, isn't it? You can file under section 13 of the Specific Relief Act, a person having no title to the suit, he cannot seek specific performance. Under section 16, a person who does not show readiness and willingness to deposit money, he cannot seek specific performance. In order to claim specific performance, you must come to the court with clean hand. So the admission made by you before the transaction, you cannot withdraw subsequently in the court. That is the, I'll further give the illustration. Yeah, where are we? Illustration here. Yeah, A may prove a statement that B that is genuine, and B may prove a statement by A that the deed is forged. So A must have been, A and B and C are good friends. C makes A statement that to C, Arey, I have fooled B. You don't know, succeeded in selling my property, giving a fraudulent representation that I am the owner. In fact, I am not the owner. Like a bloody fool, he paid me the money. Huh? So tomorrow when he becomes the owner, he cannot take up the plea. I was not the owner. And the C might give evidence against him. Yes, he had told me this fact over phone or a letter he wrote to me, conceding the fact that the transaction is sham and colorable and he is not the owner. So having made the representation, I cannot take it back. So my statement that made to C that I succeeded in fooling B in selling the property is an admission. Understood this or not? If you're not understanding, please ask me. So I cannot approbate and reprobate. Having given concession A and B, and which fact I had related to C, and C deposes against me, That's an admission. Okay. So A can take up the plea that the agreement which has been entered into is a sham, colorable document, a camouflage document, because it does not reflect the true intention of the parties, or the signature on it has been forged, fabricated. This honorable court be pleased to compare the original signature under section 73 of the Evidence Act, or this honorable court be pleased to appoint a handwriting expert who has given opinion, and I had the statement of C who had made in that regard. I got a crucial witness. So your prayer will be for cancellation of the deed. Cancellation of the deed, which suit you will file under section 31 of the Specific Relief Act. Or you may take up the plea that the document which I purchase from the builder, the plot of land or the property, does not give full description of the property. And does not give full description of the property. I have paid consideration of 10 lakh, he is showing only 5 lakh. And he had undertaken liability to pay me in the letters that I will give you a garage along with it. But to my shock and surprise, the garage is not mentioned. And I am entitled to easementary rights. So the document instrument is incomplete. I have in my possession letters written by the builder, which can be used as admission to show that before the transaction of the agreement, before the actual conveyance, he had agreed to do that. So the instrument is silent on that part. It requires rectification. So your suit will be under the provisions of section. Anybody knows the relevant section in the Specific Relief Act, section 26. That this honorable court be pleased to rectify the instrument which is sham colorable, which is against my interests. I have letters written by the builder. These are admissions. So the surrounding circumstances, the intention of the parties are not truly reflected. And I have got a document in my possession. The builder has given the parking to my neighbor, flat number 24, 25 wale ko. I have been deprived. I am seeking a declaration in the same suit that the subsequent agreement which the builder has executed to my neighbor, giving the garages and having sold them, are sham, colorable, bogus, and set aside, though you are not a party to it. So when you are not a party to those agreements between the builder and a third party, can you challenge it? Can you lead evidence under the Evidence Act? Anybody understand this? Anybody know this provision? Okay. That is called extrinsic evidence. You will be permitted to lead, because when a document is written document, when a document is a written document, parties will not be, because documents speak for itself. And parties will not be permitted to lead oral evidence in certain cases. But when there is a fraud has taken place, when there is a misrepresentation taken place, the provisions of section 91, 92 of the Evidence Act permit leading of oral evidence between the parties. 91, 92 permits between the parties. Now, since you are a stranger, a property has been sold to a third party. Can a third party can challenge the transaction between A and B? Yes, you have the right. That relevant section under the Evidence Act is, please remember, section 99. Kumar, if you can take it out, 91, मैं बताता हूँ. पहले 91, 92 आ जाइए of the Evidence Act. Extrinsic evidence. See, exclusion of oral by documentary evidence. I won't at the moment read it for the purpose of admission. So when you have written documents, you will not be permitted to lead oral evidence. But there are certain circumstances oral evidence is offered when there's an ambiguity. Section 91 clears. And 92 के proviso, देखो 92 section says that when the terms of a contract or grant are clean, and you will not be permitted to lead oral evidence. But the proviso says, proviso 1, 2, 3, 4, 5, 6, these are exception. In proviso 1, when there's a fraud or intimidation, you can lead oral evidence. And proviso 2 may existence of a separate oral agreement between the same parties, you can lead evidence. Then item number 3 के अंदर existence of a distinct subsequent agreement rescinded modifying, that is a substitution of a contract following under section 62 of the Indian Contract Act, that is a novatio taking place, you can lead evidence. Item number 5, when there is a usage or custom which incident expressly mentioned in the contract, usually can be brought. So you may take up the plea. In our community there is a particular custom, there is a usage that the provisions of Hindu Succession Act do not permit a child to be taken in adoption after the age of 15. The Juvenile Justice Act can do that, but in a particular age you cannot do that. But there is a custom in our family, in our community, which permits evidence to be led. So you examine, so that the oral evidence can be led to prove by way of a admission. 6 के अंदर fact may be grown when manner language of a document is related to existence of fact. So these are the 6 illustrations where the parties themselves. But now you are confronted with a case where the builder has entered into an agreement with third party and you are not a party to that agreement. Can you challenge it? Because you take up the plea, there are admissions, letters written by the builder agreeing to give you the garages, which he is not given. And subsequently, he entered into contract with me. I'm a third party. So section 99 will come to your aid to prove those admission. Please see that here. And to challenge the agreement. See, 99 कहता है, who may give evidence of agreement varying terms of a document? See that? Persons who are not parties to a document. So with the builder, I am not a party to your agreement. You are a third party. The builder has a, for reason best known to you, given you the garage and not deprived me. A and B were deprived. C is the beneficiary. So can A challenge the document of A? Yes. Or representative in interest may give evidence to vary, tending to show the contemporaneous agreement varying the term. Contemporary agreement means the letter written. The oral agreement, the builder get statements. The letter written by the builder are prior agreement to the registered agreement. So with great respect, the subsequent agreement executed by the builder with the defendant number 2 is a sham colorable document which has the effect of taking away my legal right and the same be set aside, or my document may be rectified under section 26 of the Specific Relief Act. Please open section 26 of the Specific Relief Act, where you go for rectification of your own document. By stating that here, see that here, when the instrument may be rectified, when through fraud or a mutual mistake of the parties. The builder is committing a fraud. He has taken more money from me and not giving it to you. Contract, instrument in the writing, not being the articles of association company, does not express the real intention. So the agreement does not express the intention, mean the oral promises given to me, the admissions of the builder are not incorporated. So these are important aspects which must be proved, and my instrument may be rectified, and the document of the defendant number 1 executed with number 2 should be set aside and cancelled. That provision is section 31 of the Specific Relief Act. We say that when cancellation may be ordered, any person against whom a written instrument is voidable, and has the reasonable apprehension that instrument left outstanding, may cause him serious injury, may sue to have the adjudged voidable, and the court may, in a discretion, adjudge it and order the deliver of the cancellation. So you can seek the cancellation of the third party. The builder is entering into fraudulent agreement with C in derogation of my own agreement, which is prior in time, and his own admissions, which has disregarded. So this is how you lead evidence in the court of law in civil cases for using the admissions of the builder. In criminal cases, the statement of the accused person, for example, he made in the bail application certain admission with regard to the commission of the crime, now which is retracting. You draw his attention. Statements recorded under section 161, where he has it, or statement recorded during the identification parade by the magistrate under section 3 of the Identification Parade Act and under section 9 of the Evidence Act, evidence tending to prove the identity of the witness. So those are the admission you can use against the accused person. Please note that here. So they are not CRPC के अंदर specifically नहीं है, CPC के अंदर the admissions are mentioned. Section order of 8 rule 5 tells you if a denial is not specific, is deemed to be admission. Then order 11 rule 1 tells you if the admissions contain in the interrogatories are admission. Then order 10 rule 1 tells you before the learned judge at the first date of hearing, ask question, what are you admitting, what are you disputing? If you admit a portion of a claim, that's an admission. Then under order 12 of the Code of Civil Procedure, rule 1, 2, 3, 4, 5, 6, वो पढ़ेंगे आप, वो admissions are clear. The admissions made by you in written statement, plain or letters, interrogatories can be considered by the court. And under order 12, rule 6, just open order 12, rule 6, that will be clear to you. Order 12 check करो, order 12 rule 6. Order 12 में admission, notice of admission, judgment on admission, order 12. Where admission of a fact has been made either in the pleading otherwise, whether orally or in writing, court may at any stage of the suit, either on the application of the part, on his own motion, without waiting for the determination of any other question between the parties, such other gives a judgment as it may think fit. The court will pass a decree. Court has recorded your statement that your evidence is recorded under the provisions of order 10. Order 10 खोल लीजिए आप. Order 10 rule 1 में examination होता है. This is examination before framing of the issues. See, ascertainment whether allegation or pleadings are admitted or denied. So ये admission stage के अंदर आप admit करेंगे claim. If you don't deny, the court can pass a decree. Then under order 10 rule 2, if your pleader is unable to answer question, the court will ask you to appear in person, because if a lawyer sometimes is fumbling, not read the case, the court will tell him adjourn the matter for 7 days. And under the provisions of order 10 rule 4, the party will be asked question. If you admit the claim, the court will pass. So please bear in mind, these are the provisions under the law relating to the admission, both not only just section 17, 18, 19, 20, 21, 22. You have to also read section 91, 92, 99 of the Evidence Act, and considering the provisions of CPC and also CRPC के अंदर bail application में statement किए हैं, FIR में किए हैं, under 161 में किए हैं, 164 के statement हैं, where confessions are recorded. The girl makes statements in a videography. Now videography is compulsory in case of minors and women who have been raped. The girls POSCO के अंदर mandatory हैं. So these are all admissions with regard to A, B, C. The judge will ask you in this question. Okay, that will clear our illustration A. So illustration, 1 minute. 21 कहाँ पे आ रहे थे हम लोग? Section So illustration I gave you with regard to declaration that the forge is not forged. By using that, you go for filing a suit under the specific relief act under section 26, and for a declaration that the agreement calls for rectification or the agreement needs to be set aside and cancelled. Okay, so the admissions can be used. Number two. Yes. A, the captain of a ship. Illustration B. A, the captain of a ship is tried for casting her away. तो ये कैप्टन साहब उनके खिलाफ एलिगेशन है कि ही इज ट्राइड फॉर कास्टिंग हर अवे. तो शिप को ही हैज बेहुरमती के साथ में यूज किया है शिप में इन डेरोगेशन ऑफ द मैरीटाइम लॉस. Evidence is given to show that the ship was taken out of her proper course. A produces a book kept by him in the ordinary course of business showing observation alleged to have been taken by him from day to day, indicating that the ship was not taken out for a proper course. A may prove these statements because they would be admissible between third parties if he were dead under section 32. So he will be permitted to use his own entries, observations, indicating that the ship was not taken away off a proper course. Because normally as a captain of ship, he has the geography of the entire sea route and what circumstances. There was a storm coming from east or west, A department. I was compelled to take a deviate from the A route to B route. So he announces, वो announcement पूरा recording होता है. There is a pit box, the black box, whatever it is. So whatever he uses, these are all admission. प्लेन के अंदर भी the captain taking different routes to avoid the क्या नाम है the maybe mountains, to avoid bad weather. They change the route, and many times accident have taken place and the cause of death. So black box के अंदर जो statement वो captain announce करते हैं, बोलते हैं, so these all become admissions. For or against, when proceedings are filed by passengers, their relatives, for claiming damages, the cause of death, commission of inquiry is appointed to know the causes. So the statements recorded by the captains in their diaries, in their black box, a pit box, and a particular box maintained, and whatever is said is admission. See, A is accused of a crime committed by him at Calcutta. He produces a letter written by himself, undated, at Lahore on the day, and bearing the Lahore postmark of the day. The statement in the date of the letter is admissible because if A were dead, it would be admissible under 32.2. So under 32.2, the cause, the reason mentioning by the person, this can be used for alibi under section 11. At the time of the commission of the crime, I was not in Calcutta, I was at Lahore, I was in Bombay. So this is the letter which he wrote to XYZ or his company. So his own statement given to other people that can be used at the time, he is not the person involved in the commission. Identity का problem है इसके अंदर. So the court can draw inference that it is possible that he has not committed the crime. So it can be used against him. And if he is dead, and the statement can be used under section 32.2 has been used very often. That is statements made in the course of a business. See that 32 says statement by relevant by a person who is dead or who cannot be found are relevant. When a statement was made by such person in the ordinary course of business, and in particular when consists of any entry memorandum made by him in the books kept in the ordinary course of business, or in discharge of the professional duty, or of an acknowledgement written signed by him, receipt of money, goods, securities, any kind of document, use, commerce, written by, signed by him, or of the date of the letter, other document, usually dated, written or signed by him. So they all can be used as admission for the purposes under section 21 and for the purposes of both illustration B and C. Because these talks of when he's dead, they can be used, and during his lifetime also, they can be used if it goes against him. That he has departed from the usual business, course of business. Okay, then D में आ जाइए. A is accused of receiving stolen goods, known them to be stolen. तो ये illustration 114 में भी पढ़े हमने. A is accused of 114 में पढ़े ना, accused of receiving stolen, receiver of a stolen good is in a commission of the offense. He offers to prove that he refused to sell them below their value. He offers to prove that he refused to sell them below their value. A may prove these statements, though they were admission, because they were explanatory of the conduct influenced by these facts in issue. Now, if a stolen property is there, normally you will sell it at a lesser price. 1000 रुपए की चीज आप 100 रुपए में खरीदेंगे, अरे 200 रुपए मिल जाए काफी है. But I refuse to reduce the rate market value. If 1000 rupees, I want 1000 rupees. So, in a prosecution which is filed by the police officer that you are a receiver of a stolen good, मोबाइल चोरी किया है, बेचा है, सोने की चीज चोर ने लाके आपको बेचा है, you have received this, isn't it? This defense he can prove to show that I am a purchaser of this, I'm a bona fide purchaser, and nothing to do with this. So these are the admissions which can be used for him and against him in the matter. A is accused of fraudulently having in possession counterfeit coin which he knew to be counterfeit. So counterfeit coin is a crime which we learn under the provisions of section 414 में पढ़े थे हमने, isn't it? वो receiver of the stolen food का example 410, 411 में पढ़े थे हमने, isn't it? ये illustration 14 में भी आया था आपको. Then he offers to prove that he asked a skillful person to examine a coin as he doubted whether it was counterfeit or not. And the person did examine it and told him it was genuine. So he may take up the plea that I am not a habitual offender indulging in counterfeit coins as sought to be claimed by the prosecution. In fact, the money when it came in my possession from XYZ places, I took the opinion of the expert. I went to the bank manager told me this is genuine. So he may examine the banker. Yes, he had come to me to take my opinion. That is an admission. Okay, what the bank manager told him about this, that will show that he is not a habitual offender dealing in counterfeit coins. Okay, A may prove this fact for the reasons stated in the last preceding illustration. Okay, this is the illustration dealing with section 21. Anybody has any question before I jump to section 22? पूछ लीजिए. Yeah, if no questions, I'll come to 22. When oral admissions as content of documents are relevant, oral admission as to content of documents are relevant. तो section 91, 92 अभी पढ़ा है मैंने आपको. Section 91, 92 and 99 of the Evidence Act. 91 onwards deal with extrinsic evidence. When can be given? That is called exclusion of oral evidence by documentary evidence. 91, 92 का चैप्टर आपको अच्छी तरह पढ़ने का till 100 तक. Till 100 तक I will deal with it here in the next lecture when we are dealing with it. Very important lecture, not only from the examination point of view, but especially in practice point of view. When you want to become a good trial lawyer, strong, formidable lawyer, you must know the Evidence Act correctly, and particularly remember when there are documentary evidence and you want to lead oral evidence, how you are prevented from leading and when you are allowed to open. So this section 22 will tell you how to use the provisions of section 91, 92 and 99 of the Evidence Act till 100. Let us see that. Oral admissions, because CPC also kaha ke express or implied. The expression implied mean oral. So under section 9 of the Indian Contract Act padhe aapne, contracts are express or implied. Express mean normally generally in writing. Mention kiye हुए. Or implied mean which are presumed orally. जरूरी नहीं हर contract must be in writing. जरूरी नहीं हर letter must be in writing. Certain contracts, certain instruments can be, even the Transfer of Property Act tells you certain transfers can be oral. If you want, anybody knows the relevant section where the oral, there are oral agreements under the Transfer of Property Act. किसी को याद है by heart में? There is a section which tells you oral transfers. देखो section 11 तो नहीं है वो. Just kindly check in Transfer of Property Act, Kumar. There is a provision, specific provision with regard to oral transfers. Section 9. भूलिए मत भैया, पढ़े हैं आपने. Section 9 खोलिए. Section 9 of the Transfer of Property Act खोलिए. A transfer of property may be made without writing in every case in which writing is not expressly required by law. Can anybody give me one illustration of this? लगता है TP Act भूल गए आप लोग. A transfer of property may be made without writing in every case in which writing is not expressly required by law. Now उसके लिए लीज खोलिए आप section 106, 107. You will have to remember these. All these questions may crop up. Judges will ask you these questions when you are arguing a case. If you are not able to answer the question, your case will be dismissed. Whatever you read and prepared will not be asked in the question, especially in the higher courts. Now, 107 खोल लीजिए. A lease of immovable property from year to year for a term exceeding 1 year may be made only by registered agreement instrument. Then all other leases of immovable property may be made either by registered instrument or by oral agreement. Underline this word. Again, this is one illustration. Oral agreement accompanied by delivery of possession. Monthly tenancy under the rent control legislation need not be by virtue of a written agreement. अगर लैंडलॉर्ड ने आपको कब्जे में डाल दिया, जगह दे दिया और रेंट ले लिया, it is a oral tenancy. रेंट रिसीट इटसेल्फ दिया भी नहीं दिया भी, आपने चेक्स ट्रांसफर किए बैंक से अमाउंट, तो सेक्शन 9 of the TP Act permits you oral transfers. So don't be under the impression that oral transfer nega. Now gift under the TP Act is section 124 में, it must be in writing and signed by 2 witnesses. Generally under the 125 124 पढ़ेंगे आप gift, 122 से gift हो रहा, it must be writing. But under the Islamic law, Mohammedans can make oral gift, that is called hibanama. मालूम है ना आपको? A hibanama can be oral gift. A Muslim can give a by oral gift to any Tom, Dick, and Harry. But whereas a non-Muslims cannot give, there must be a registered instrument under 122. You cannot even give if you are a non-Muslim to others without a registered agreement. As a Muslim, you can give it. Similarly, a will of a Muslim need not be in writing. It is more liberal. You can bequeath your property, a Muslim, by 1/3 with the consent of all the heirs, full property. In other cases. So these are the illustrations with regard to oral transfers, which you all should know that here. So the TP Act and Evidence Act tells you when oral admissions 21 speaks of as contents of a document are relevant. So you cannot take up the plea that here यहाँ पे oral agreement हुआ है, लोग हंसते हैं, मजाक करते हैं, अरे how it is possible. So oral admission as to contents of a document are not relevant unless and until the party proposing to prove them show that he is entitled to give secondary evidence of the content. Secondary evidence is given under section 63, 65, 65A and B of the Evidence Act. 65 secondary evidence come into play. Number 1, primary evidence is not available. That is written document, registered agreement, not available. Because section 64 of the Indian Evidence Act tells you primary evidence must be by original documents. Please just go through this. Open your section 62. 62 speaks of primary evidence. I discussed with you in my first lecture. You must have forgotten. Primary evidence is defined under section 62. 64 tells you proof of documents by primary evidence. Primary means original documents. Original document नहीं, घूम गए आपके पास xerox copy हैं, then you can resort to secondary evidence under section 63. Please note that. Certified copies, xerox copies, counterfeit copies, then oral account of the contents of document given by. So a Muslim will make a oral hibanama in presence of 2 witnesses. Or declaration करेंगे affidavit. Yes, in my presence, the grandfather of this plaintiff had given the properties in hibanama. So that is a oral account of the contents of a document. तो उनके पास document था, घूम गया हो. Please note that here. So you are permitted to lead secondary evidence on the contents of a document under the rule even after contain, unless the genuineness of the document produce your opinion. So you don't have a certified copy of the gift deed. You may say, I lost it. Not traceable. When lost it, not traceable, not to worry. उसका procedure है आपको. Under the provisions of section 65, when a document is lost, 65 tells you destroyed and lost. 65 clause C check करें आप. When original has been destroyed or lost, section 65 C of the Evidence Act. When a party offering evidence of the contents cannot, for any other reason, not arising from his own default, neglected, produce in reasonable time. So you can take up the plea, lost, I lodge FIR. मेरे पास xerox copy है. Or you may take up the plea that the original document is in the possession of the defendant number 1. He is not parting with it. मुझे copy दिया. Agreement of sale किया ये आदमी ने. Agreeing to hand over possession in 6 months. He took me to registration office. I signed the document and he told me, go home happily. I will collect the document and give you. He never gave me. So you filed a suit on the basis of a xerox copy obtained or certified copy obtained. So that can be used as a secondary evidence. Please note that. You cannot be shut from the court of law because the original is not available. Or you may write to the other side. This is to place on record and inform you that there is an agreement between you and me with regard to purchase and sale of the property in question. You took me to the registration office of the sub-registrar Mumbai. You asked me to sign document and told me the document will be made available after 8 days. I believed your representation. I signed the documents. And you gave me a just xerox copy which is signed by you without registration. I hereby call upon you to produce the original document in the court of law, as I am seeking relief of specific performance against you for having committed breaches. That is your remedy. So you will have to give a notice under section 66 Collier Evidence Act. Rules as to notice to produce. देखिए आप secondary evidence of a content of a document referred to in 65 clause A shall not be given unless the party proposing to give the secondary evidence has previously given notice to the other party. So please give notice if you are a defendant in the suit or a plaintiff relying upon a secondary evidence of a document which is not in your possession and only copy with you and the original document is with the other side, give a notice under section 66. अगर आप notice नहीं देंगे, court will not allow you to lead secondary evidence. You have to discharge your burden first. You have to lead a foundation as to when you can lead oral evidence. This is an example where the original document is in possession of the other party. 65 also tells you of a situation where the original document is lost. आपने क्या किया? मैंने FIR lodge किया. Produce the FIR copy. There was a burglary in my house, robbery in my house. कोई चोरी करके लेके गया. अभी तक recover नहीं हुई. FIR lodge, my documents have been lost. My jewelry is looted. My cash is gone on an incident. Along with it, very valuable documents are lost. Fortunately, xerox copies of which I had kept with my CA for the purpose of income tax payment. I got a copy. The moment I lost, you prove it. That is how then you examine. You can examine your CA. Yes, this is the copy which was kept to me. This copy I had taken from the original. Now under section 63 में check करेंगे आप evidence में act में the copy taken, certified copy number 1A, item number 2, copies made from the original mechanically are admissible. Number 3, copies made from compared from the original, then counterparts of the document, then oral account. 5 situations allow you to tender secondary evidence in 63, and situation number A, B and C, D and E. यहाँ पे भी 5 situation in 65 A, B, C, D, E permit you to lead secondary evidence. Kindly remember that. ये दोनों के अलावा when there are electronic records, email messages, you may take up the plea that here. Accused is the person who has committed the crime of his friend in a hotel room. CCTV camera का report camera है. Isn't it? They were the only proof. CC, they were the last seen people. CCTV camera recording किया है. Are WhatsApp messages sent to friends about the enmity, email messages. So these are all under electronic system. So the law कहता है, when you open section 59, proof of oral document, contents of a document of electronic record may be proved by oral, may not be proved, may be proved by oral evidence. See, except all documents, all fact except content. You cannot prove the electronic document like CCTV camera, your oral messages and your email messages. You cannot say that orally. Why? You have to produce them in the court itself. You have to bring and record the email message, the instrument from which it is this particular message is recorded, and CCTV camera ka report aana chahiye. These can be manipulated these days. You know that these can be manipulated. All youngsters are very clever. Huh? Your photograph can be morphed and put it in the WhatsApp and said that as if you have committed the crime. इसीलिए there are safeguards under section 65A and B of the Evidence Act. Admissibility of electronic record, उसके लिए you require to obtain certificate from the electronic authorities. See that? 65A check karo. Special rules as to evidence relating to electronic record. How the admissions can be proved here. The contents of electronic record may be proved in accordance with 65B. Now 65B क्या कहता है देखिए. Notwithstanding anything contained in this act and in an electronic record which is printed or a paper stored, recorded or copied in optical or magnetic media produced by computer hereinafter referred to as the computer shall be deemed to be a document if the condition mentioned in the sections are satisfied relating to information computer in the question shall be admissible in the proceeding without further proof or protection of the original as evidence of any contents of the original of any fact stated therein, of which direct evidence would be admissible. So if you bring the instrument itself directly to the court, तुम बोलेंगे इलेक्शन के टाइम पे ये पॉलिटिकल पार्टी बी पॉलिटिकल पार्टी में फ्यूड हो गया, झगड़ा हो गया, मारम मारी होगी, वोट्स वर डिमांडेड बाय गिविंग ब्राइब. You recorded the statements. Your document invoice should be produced before the court of law. डॉक्यूमेंट और आपने मैसेजेस को ट्रांसमिट किया. ये मैसेज आजकल तो ट्रांसमिशन इज ए फैशन इन व्हाट्सएप एंड मीडिया के अंदर, इजंट इट? फटाक करके मैसेज चले जाते हैं गूगल में, फेसबुक में. दोस मैसेजेस cannot be proved unless you obtain a certificate. देखिए कंडीशन नंबर, द कंडीशन पैराग्राफ नंबर 2 से कंडीशन रिफर टू नंबर 1 2AC बराबर पढ़ेंगे आप. नंबर 4 देखिए. In any proceeding where it is desired to give statement in evidence by virtue of the section, a certificate doing any of the following things, it is to say identifying the electronic record. Certificate चाहिए from the information technology officer. Number B, giving particulars of the device. आपका मोबाइल फोन कौन से डिवाइस से ये रिकॉर्डिंग हुआ है उसका पर्टिकुलर चाहिए, वो देख उनके पास पूरा है. Then dealing with any other matter to which the conditions are required. So ये particular section 65A 65B has been a subject matter of discussion before the Supreme Court in 5-6 judgment, the last of which was the judgment of anybody knows? Anybody knows? A 5-bench judgment of the Supreme Court in the year 2000. Anybody knows? अर्जुन पंडित राव खोटकर केस याद कर लीजिए आप, वो खोल के पढ़िए. 5 जजेस का केस है. उसमें दिया गया है. There were many conflicting judgment उससे पहले हैं. I will take up a special lecture for this, discussing the various judgments, conflicting judgments, and the latest judgment up to Arjun Pandit Rao Khotkar's case, which is beautifully penned down, authored by Justice Nariman as to how the evidence of secondary evidence can be given in electronic form. So that is the evidence you can give. Now come back to 21, please. So 21 itself you cannot read in isolation. When it is speaking of a secondary evidence, ये सब आपको secondary evidence के rule जाना जरूरी है. Please note that. That is 22 we are dealing. So when dealing that here, rules here and after contain, you can give the content. That means oral admissions as to contents of a document are not relevant unless until the party proposing to give show that he is entitled to give secondary evidence of the content of such document under the rules here and after contain, unless the genuineness of a document produced is in question. So please remember section 63, 65, 65A and 65B of the Evidence Act thoroughly. Okay. Yeah. Next, 25A, 22A. Yeah. When I'm supposed to stop, you can stop me. When an oral admission as to content of electronic records are relevant. Now, a specific section has been drafted. Now, the section 22 dealt with the situation enumerated under the provisions of section 63 cases. I mean, 63, 1, 2, 3, 4, 5 and 65 A, B, C, D, E. Now, 22A deals with a case under section 65 A and B, electronic record, and section 59, which tells you cannot give oral evidence with regard to the contents of a electronic record. There's a bar. Normally, if a person has seen some event, he can give direct evidence. Under section 60, you heard something, that is called best evidence rule. Best evidence rule do not apply to electronic evidence. Electronic evidence के लिए device itself must be produced before the court and a certificate from the information technology officer under subsection 4 of section 65 must be produced. Otherwise, your evidence is of zero value. Yeah. देखिए section 22A. When oral admission as to content of electronic records are relevant. Oral admissions as to contents of a electronic record are not relevant unless genuineness of the electronic record produced in the court. So under the Representation of People's Act, you are a political party member, you are seeking to cancel the election of another candidate, stating that here he has procured votes using religion, giving fraudulent means by distributing notes. और he has admitted that मैंने notes बांटा है. मेरे भाइयों बंधुओं सब everybody come and take notes and give me notes. Note ले जाइए, वोट दीजिए. Note लीजिए, उससे there are many of the politicians openly say that. You have seen this. Such matters are come on record. So Pandit Rao, Arjun Pandit Rao's case is one such case which arose from Maharashtra, when Mumbai. A member of a political party recorded the statement of another political party. So it's a beautiful judgment. When I deal with करेंगे अभी पढ़ के आइए, it becomes easy. But in a 1 hour's time not to deal with it, उससे और बहुत सारे अनवर का judgment भी है इसके अंदर, टबास्को पर कॉर्नर का judgment भी है. Beautiful judgments here. So यहाँ पे the admissions made by a party stating that मैंने नोट बांट के वोट ले रहा है. So if somebody has recorded it. Now in USA, the gentleman, the police officer, white gentleman, killed the black man because $20 का कुछ उसने complain आया था. तो उसकी मुंडी के ऊपर पैर रख दिया उसने for 10-20 minutes. And that was recorded by one of the passerby bystander. And every statement, what he said, the police officer was recorded. And the victim, what is saying, I am getting suffocated, don't do that, please get out. But the officer was repeating, you deserve to be killed. You don't deserve to leave, you are committed. These are all admissions which has been recorded. And in USA, the law is more liberal, you don't require certificate. Certain state. On the basis of the recording done by that lady, it is on the YouTube, that man has been convicted for 22.5 years jail for killing the black man in the very unfortunate case. We read that is open now. Recently, punishment has been recorded. solely on the basis of electronic record evidence. So electronic record evidence is a very powerful mean. But हमारे इंडिया के अंदर is also being used, but unfortunately there are a lot of manipulation. Safeguards are there. So section 22 tells you how the oral admissions can be used against persons. अगर मेरा conversation आपने recording कर लिया, admitting certain your debt, extending your limitation, you can say that Mr. Shah has made confession, admission, admitting liability. So I am producing his conversation and a certificate of the officer under secondary evidence. It's admissible. It's a oral. It may be. I'm admitting it. Okay. 23 में आ जाइए. 23 is the last subject on this topic. 24 confession कर लूंगा मैं. Admissions in civil cases when relevant. 23 applies specifically to civil cases. Section 17 to 22A applies to both civil and criminal cases. Please note that. Section 17, 18, 19, 20, 21, 22A तक it applies to both civil cases and criminal cases. But 23 is made specifically designed for civil cases. Let us see it. Admissions in civil cases when relevant. In civil cases, no admission is relevant if it is made either upon an express condition that evidence of this is not to be given or under the circumstances from which the court can infer that the parties agree that evidence of it not to be given. Now, civil case is going on between A and B or property dispute, matrimonial dispute, arbitration dispute. Judge bolega, parties are near relation, go and settle the matter. So parties agree to have a meeting with their councils and in the chambers meeting. Whatever discussion taking place between the parties, they may say that this is without prejudice to the rights and contention of both the parties and should not be used in evidence. Please note that when you are representing a plaintiff or defendant, when both the parties are exploring the possibilities of a settlement of a big matter or small matter, whatever matter, first send a recording letter. Pursuant to the direction of the Honorable Court, I am fixing meeting at my chamber or so and so place. You may remain. Please take notice that here the whatever discussion that may take place in the said meeting are entirely without prejudice to the rights and contention of my client and the parties, and they should not be used in the trial subsequently. So if that is done, that cannot be used in the court. Number one. Now, under the Arbitration Conciliation Act, there's a chapter called Conciliation. The judges are sending the matter for a mediation and conciliation. Now, there's a specific section, if I'm not mistaken, section 77. Just open, Kumar. If the parties don't agree before a conciliator for settlement, that statement cannot be used elsewhere. Please open. I'll just open my Arbitration Act. Where act? Yes, I have the Arbitration Act. इसमें arbitration में all of you have read it and maybe arbitration हो गया आपका नहीं? Part 1 is arbitration. Part 2 is enforcement of the Foreign Award Geneva Convention, New York Convention. Part 3 deals with conciliation. Conciliation settlement के लिए भेजते हैं. देखो यहाँ पे conciliation fail हो जाएगा. Can you use that statement? Now, specific section है disclosure of information. Section 70 check करो आप. Communication between the council and the parties. 69 and 70 of the Arbitration Act. I will just use. Section 75. Confidentiality check करें. Notwithstanding anything contained in any of the law for the time being in force, the conciliator and the parties shall keep confidential all matters relating to conciliation proceedings. Confidentiality shall extend to the settlement meeting, except where the disclosure necessary for the purpose of implementing enforcement. So, the discussions cannot be used. Similarly, under the Lok Adalat Act, the parties judges try to explore the meeting, they cannot be used in evidence. Kindly note that. Similarly, in civil cases, all civil cases, either in the High Court proceeding, City Civil Court proceeding, District Court proceeding, Civil Judge Senior Division, Junior Division, Court of Small Causes, Mufassil Court, Munsif Court, all civil courts. When the parties are holding conferences and meetings are without prejudice to the rights and contention of the parties, and if any concession is made, any admission is made, admitting liability should not be used as admission. Court will not take it. Sometimes judges get influenced. अरे इसने admit कर लिया है. They draw inferences. But normally, as a rule of evidence, it is justice, equity, good conscience. There is no room in this matter. Okay, आज के लिए then देखिए explanation check कर लीजिए आप. Nothing in this section shall be taken to exempt the barrister, pleader, attorney, vakil from giving evidence of any matter. He may be compelled to give evidence under 126. Privileged communication of a lawyer under section 126 cannot extend to all matters. Please note that. If a client tells you, I have committed the crime, मैंने चोरी किया है, document fabricate किया है, please defend me. That communication between you and him is a privileged communication. But after accepting the court, वो दोबारा बोलेगा मैंने दोबारा crime किया है. That is not privilege. That you can report to the police and get him arrested. After taking assignment, after appearing for him in the court of law, मैंने बोलेगा मैंने दोबारा robbery किया है, मैंने और एक signature forge करके पैसा निकाला है. That is not protected, and you can be a witness. No? You can be a witness and the client can be convicted. That yours is an admission. You can make a statement. My lord, he admitted before me that he has committed the crime even after the assignment. Fresh crime. That is not protected, and that is an admission made by a counsel. Anybody want to ask me any question? आज के लिए इतना बस. I do not want to bore you too much. पूछ लीजिए अभी. Any question? Ashutosh Kumar, any questions? Yuvraj?
No, sir. I don't have any.
खुशबू नहीं समझ लगता है समझ में आ गया A to Z. हाँ
Yes, sir.
Sir, one question.
हाँ बोलिए बेटा.
Sir, अभी आपने जो 1 second, sir. Sir, in this explanation, you said that the vakil or anyone cannot give evidence. Okay, so can the judge ask it from section 165 of the same facts?
No, offense committed subsequent to taking the brief. Prior commission cannot be either privileged communication. Advocate cannot be compelled to give evidence. But for a subsequent crime, if your client commits, you have a right, you should report to the police. And in fact, when you become a witness in the matter, you should give up the brief. Please note that it's a ethical rules frame under the Advocates Act. An advocate cannot be a witness and a representing lawyer. उसका illustration check कर लीजिए आप 126 में आ जाइए. Illustration में आ जाइए. A client says to be an attorney, I committed forgery and I wish you to defend me. As a defense of a man known to be guilty, is not a criminal purpose, this communication is protected from disclosure. Because this is an offense committed prior to the engagement of a lawyer, prior to charges being framed. Next. A client says to B attorney, I wish to obtain possession of property by use of forged deed on which I request you to sue. This communication being made in furtherance of a criminal purpose is not protected. So as a lawyer, what will you do? It's a duty cast upon you to inform the police. If they come to know, police inquires you, इसने कहा कि yes, this is what he told me. Even subsequently, he wanted to commit robbery, dacoity. He wanted to commit fabrication. 467 लगेगा, 468 IPC लगेगा. And you will be giving evidence. Because you are a prime witness, in many cases, advocates have been arrested. You know that, yeah? Central Bureau of Investigation arresting several advocates and solicitors in respect of fraudulent transaction. Rightly or wrongly, I happened to appear for one advocate solicitor, which is on record. When you open the Google, milega aapko. Mahendra Jain solicitor. His name is there. And I appeared for him in the court of law, applied for quashing that he, the advocate against whom the charges have been framed, cannot be prosecuted because he is acting in his capacity as an agent. To relying upon for earlier judgment of the Supreme Court quashed against me. That's a matter reported. You can see that when you open the matter argued by Nusrat Shah, quashing charges of an advocate implicated milega aapko. It is there. But an advocate, the client says that subsequently, subsequent to framing of a charges, I intend to take possession forcefully and kidnap, teach him lesson, fabricate, and you will be a witness in that. Because police is going to investigate the matter. आपके पास आएंगे, बोलेंगे किसने बोला था कहे, ये क्या किया, डॉक्यूमेंट कहाँ रखे. But a forgery or any crime committed prior to your assignment is protected. That's privileged communication under section 126 of the Indian Evidence Act. There are certain communication between husband and wife are protected. They are privileged communication in certain circumstances. Privileged communication between attorney and the client. Privileged communication of the state government of India. These are public documents under the Secret Act. We cannot be disclosed. But the Supreme Court judgment in SP Singh's case tells you in what manner they can be disclosed. Okay, that देख लीजिए. और कुछ बोलना है? Any other question? Is that clear?
Yes.
Yeah, I will. Next lecture will be tomorrow. That is next on Friday. Confession लेंगे, which is applicable to only criminal cases. 24, 25, 26, 27, 28 से लेकर 30, लेकर 27 तक ले जाता हूँ कल. All these sections are very interesting. Read with the provisions of section 100, 102, 103 CRPC. Okay. Chalo, we'll wind up for the day. If no other questions, I will hang. I will leave. Okay. Any more questions? Okay. Bye bye. Good night.
Good night.
Good night.